Great. Thank you very much, Chrissy. And welcome everyone to our presentation on Nexus in a post-Wayfair world. Boy, hasn't the world changed since that Supreme Court decision in Wayfair. And I am pretty sure after this conversation today, you will see that we are not done changing. So today's presenters I want to introduce to you. I will serve as your host and help us work through the polling questions as they come up. But Kathy Stanton is a partner in our practice here at Cherry Beckert in our firm, and she is our national leader for state and local tax services. And she will be speaking along with Monica Tillett, who is a director, an experienced professional in our state and local tax services group as well. And these two folks, basically, we're going to clue you into the conversations that we've been having internally, we've been having with our professional peers, we've been having with our clients, and even some state tax authorities as to where does the world go now that we are past the Supreme Court decision. So Kathy, I will go ahead and turn it over to you and let you tell us about what we're going to cover today.
Great, thanks, Sarah. And I saw on the introduction slides, it had my credentials and as a CPA and Master of Tax. We did not have Monica's there. She is an attorney, so she is speaking from some of that background and experience as well, which comes into play when we get into a lot of the limitations, constitutional issues, and so forth. So I thought I would mention that. And so today's topics that we're going to talk about, we have a lot to cover today. We're going to talk about sales tax nexus at first, the Wayfair. We're not going to spend a ton of time on the details of the Wayfair case because I think most people understand that, but we will have some people on the call that aren't as familiar. So we will touch base and review Wayfair a bit. But I'd like to indicate there that that's really a case that has made taxpayers very concerned, and I actually labeled it taxpayer defeat. We have been fighting for years to try to limit the state's taxing reach to businesses to a reasonable approach so that there's not an extreme amount of compliance. But certainly in Wayfair, the taxpayers have now been defeated, at least in part. But there are still some defenses remaining. So the second thing we're going to talk about is marketplace facilitators. What the heck is that and how does that impact me? The defenses remaining for sales tax nexus and prevention of the state's potential overreach. And then we're going to change course and look at the next challenge of income tax nexus. And Monica is going to start that discussion. Little known federal law protection. Many companies, business people don't understand or aren't familiar, haven't heard of a federal law protection that is still there for some sellers of tangible personal property, and what's actually happening there and how the states are actually trying to erode at that federal law protection as well. So yes, Wayfair for income tax, and what does that mean? What does that look like, and what direction are the states headed? So we can go to the next slide, and let's start with the taxpayer defeat. So before we dive into sales tax nexus a bit more, I wanted to just give a background, just so not a lot of people in the business world have a depth of knowledge in sales tax. So this is just a sales tax 101 basics course. So the rest of this presentation discussing sales tax nexus will make sense to you. So first of all sales of tangible personal property are generally subject to sales tax unless there's an exemption available. So if your company sells tangible personal property, you may have sales tax unless there's an exemption available. Most common exemption is a resale exemption. If you think about a manufacturer that's selling to a distributor who's selling to a wholesaler, to a retailer, then to the customer, each one of those sales, there's a resale exemption available until you get to the end customer who ends up really bearing that tax. And so that's a very common exemption, as well as you could have a customer that's the government or charity that may have an exemption as well. Alternatively, sales of services are generally exempt unless the state enacts a specific statute to tax that service, although there are a handful of states that tax the majority of services. So if you think about your revenue streams in your business, are we selling services? Are we selling tangible property? Are we selling intangible property? Where we get into complexities is in the technology industry. Software as a service, is it tangible? Is it intangible? Is it a service? And the states view all of these technology areas very differently. Some states may view downloaded software as sales of tangible personal property. Some view it as intangible property. So every state has its own unique sales tax definitions. And generally, if you have one contract where you have all kinds of things involved in the contract, services and property, the states are going to look to a true object test of what are they really buying. And if the tangible property is a super small incidental component, maybe the transaction can be deemed a service, but the states look at what is that true object. So that's an oversimplification, but just remember that sales of tangible personal property, subject to tax, sales of services, only subject to tax in the majority of states, and unless there's a specific statute that taxes that service. So you can go ahead to the next slide. So pre-Wayfair. If you're a vendor, you're selling, right? You're a business, you're selling something, selling services, selling property. How are the states imposing that sales tax collection obligation on vendors? Well, traditionally, and under the Quill case, it was always a physical presence. You had to have some form of physical presence in the state for that state to require you to collect sales tax. However, that requirement has been expanded by the states, and they've included affiliate nexus. Are you paying someone a pay-per-click nexus, where that affiliate or that agency type nexus, they're physically located in the state, it's attributed back to you? Do you have in-state software, meaning did you download a cookie that you own on someone else's computer that's physically in the state? So you can see how the states have gotten really aggressive in trying to push the envelope in just that physical presence expansion. Then the states moved from that physical presence and saying that, okay, we understand in a lot of cases we can't make vendors collect because we don't have any way to assert physical presence back. So we're going to enforce a use tax notice and reporting requirement. We still have some states with this obligation as well. Notably, Oklahoma, Washington, and Pennsylvania. If you have taxable sales into those states of over only $10,000, there's a use tax notice and reporting requirement where you have to send to the state who bought taxable items from you. You have to send notification to the customers. You have to have certain language on your website. And by the way, if you don't do it, there's a $20,000 minimum penalty. So even if your sales are under a Wayfair threshold in Washington, Pennsylvania, Oklahoma, you want to look at this use tax notice and reporting, and you may actually choose to just start collecting and remitting because the majority of our clients have found that notice and reporting requirement is actually more complex than just collecting and remitting. And then we had a marketplace provider type argument that, and the states were starting to litigate Amazon. You're the marketplace, you should be collecting. So we've had all these types of arguments and activities happening prior to Wayfair. So then when we get into Wayfair, okay, we can go ahead and pull up the bullets on that. Wayfair had pretty much one issue before the U.S. Supreme Court. And I was really honored and felt like I had a great opportunity. I was actually at the Supreme Court and was able to hear the oral arguments. And so there was an excellent just experience. But there was one issue before the U.S. Supreme Court in the South Dakota versus Wayfair decision. And what that one issue was is physical presence necessary under the constitutional limitations and under the Commerce Clause or Due Process Clause. Is physical presence necessary for a state to assert its taxing jurisdiction over you? And this is a huge question. It really is a game changer in the state tax world. If I don't have physical presence, can a state tax me? And so I'm just sitting in one state, never step foot in another state. And so the Wayfair decision ended this decades-old battle that physical presence is no longer necessary. Economic nexus is enough. An economic nexus simply means that you're deriving enough economic benefit from that state because you have customers in that state that is enough of a connection for that state to assert its taxing jurisdiction over you. Now I'm talking specifically sales tax here. We have some differentiation in the other tax areas. If you have nexus for one tax, may not mean you have nexus for another tax. But for sales tax, no longer physical presence. This is really, really a game changer. We can go to the next slide. And that we're looking at the South Dakota case was 100,000 sales or 200 transactions. I am getting some feedback. Someone may need to mute their line if they're, or Chrissy, if you can mute all lines. I'm not sure, except mine. But 100,000 of revenue or 200 transactions in the state of South Dakota was determined to be enough with the state of South Dakota. 43 states now and DC have passed economic nexus laws, and there's only 45 states that actually have imposed sales tax. So that's pretty significant. And then even for small sellers, when you have a transaction threshold, 200 is not that much. What if you're only selling an app and the app is 99 cents? 200 transactions is pretty small. So this is really, really, thank you for whoever muted your line. This is very problematic. And I would say the Wayfair decision, I've been practicing, I'm in my probably 33rd year of practice, and the Wayfair decision is the biggest change in the state and local tax world that I've seen in my entire career. So it really is that monumental. And I want to really alert technology companies. E-commerce, people are thinking that, well, Wayfair is really, an e-commerce issue. It's the Amazon, the eBays, people that are selling physical property over e-commerce. No, unfortunately, it's not. And that was the most frustrating thing, sitting in the oral arguments, just knowing all the taxpayers that this is going to affect that no one is even thinking about now, and especially in the technology area with software. Software as a service, I'm thinking about a lot of our clients that are growing in that area and not even knowing that they have some sales tax issues. So we're trying to make sure that we're notifying everybody as quickly as possible. So what I will say, that I think the transaction threshold is very, again, like I said, is very problematic. Is 100,000 really enough in all states? But we'll move on. We'll talk about that more. So let's move to the next slide. So here are the states, all of the states that have imposed an economic nexus requirement. The blue states don't impose a sales tax. And there's only 2 states that do not currently have a statute in place, but they do have proposed legislation. I'm sure it will not be too long before they impose economic nexus as well. Once Wayfair was decided, most of the states actually had to enact statutory language in order to authorize and enact what is our Wayfair threshold going to be. So it took them some time. We have staggered effective dates. Each of the states can have different dates where it's effective. So you really have to look at your sales by state. What are the Wayfair thresholds? And when did we pass those Wayfair thresholds so that we have to start collecting sales tax? And that we can have different rules come into play. For example, some states will look at a rolling 12 months. So South Dakota, I had $90,000. When do I exceed that 100,000? Some will look at a rolling 12 months. Some will look just at the current year or the prior calendar year. We do have different measurement periods. Unfortunately, in the state tax world, none of the states can adopt the same rules to make everybody's life easier. Unfortunately, they adopt their own rules that they see fit for their state. So let's go to the next slide. So the results. Okay, Wayfair started, the case was June 21st, 2018. Economic Nexus statutes have been enacted at a staggered date since then. But a year after Wayfair, what has happened? What's the result? So the National Council of State Legislators estimated that in 2015, so just 2015, the states lost over $25 billion in sales tax revenue because they couldn't force sellers to collect. The GAO said, well, we actually think it's probably 8.5 to 13.4 billion in 2017 due to a lack of collection. The estimates, did they consider that Amazon's starting to collect in a lot of states? I don't know, but the result is that 1 year afterwards, the additional revenue is about 50% of what the GAO estimate is. And what I will say is that I think the GAO estimate probably is accurate, if not light, because there are many businesses that have not started to collect, even though they may be meeting some thresholds. So that's where we are 1 year later. We have lots of clients, lots of companies, even foreign. Now you have foreign sellers selling into the U.S. It doesn't matter if they're in Germany or UK. If they have sales into the States, treaties do not protect foreign sellers. And because treaties are just at the federal level. So that becomes very interesting. How do states enforce it against foreign countries? I spoke on Wayfair in Singapore in October. It's just far-reaching really globally. But I will say on an international level, they're taking steps in other countries to impose digital services taxes and so forth. So other countries are kind of looking at the same type of aspect as Wayfair. It's very interesting. So we can go to the next slide.
All right. So we have reached our first polling question. Chris, if you want to bring that polling question up for us. Okay, so the poll is open now. The question is, it's a true false. So with Economic Nexus, a business can be deemed to have nexus with a taxing state just by having a minimum number of sales transactions in that state. True, false, or not sure? You can take a pick there, and we will take a look at that. But this is really just more to log your attendance and your opinions. There is no wrong answer. You will not lose your CPE by answering one of these, but by not answering, that does cause problems. So let's make sure that you have a moment here to answer this polling question number one. So Kathy, you mentioned you were in Singapore. So I take it the international community is very aware of what is happening here, probably on the lead from multinational retailers and sellers and those making sales. So this has had a ripple effect around the world.
Yes, and there still, I'm sure, are a lot of sellers that aren't aware, but we're trying to get the word out through our Baker Tilly network. But yes, the information is spreading.
Okay. All right, Chrissy, I think we're ready to close that poll. So thank you very much. And let's talk about now our next agenda item, which is marketplace facilitators. What is that?
Okay, let's go to the next slide, and I will speed up a little bit so we have enough time to discuss other items. But so marketplace facilitator, I think in your mind, Amazon, eBay, Etsy, anyone who has a platform that third-party sellers are selling through the platform. So marketplace, Amazon is a marketplace facilitator. So these are the states, 38 states have adopted marketplace facilitator laws where Amazon actually has to collect the tax for taxable sales running through their marketplace and remit the tax. Now, this isn't going to alleviate all sales if the company also has its own website sales. And this creates a whole host of issues and problems. And also, I want to talk about really who is a marketplace facilitator. But these are the states that have also imposed a marketplace facilitator collection requirement. We can go to the next slide. So what is a marketplace facilitator? In New York, you have to actually be advertising for the seller that's selling through your platform and payment processing, handling that cash. So like an Amazon, for example. That's reasonable. They are advertising. They are handling the cash. So, it's more reasonable, to expect that platform to be a marketplace facilitator. But let's go to the next slide. California, however, is much more broad, and they say advertising or processing payments. So they're looking, at one or the other. And it's like, whoa, wait a minute. If we're just advertising, can we actually be a marketplace facilitator? Can you go to the next slide? I think I have the facilitator. Okay, I didn't, but you can stay here. So California, some of these statutes, they have just been imposed in this past year. The states have enacted just these broad statutes without really figuring out the details, and that's really how the states operate. And they say, okay, we'll clean up and figure out the details later. So this creates a whole lot of issues. Who's responsible if the tax isn't right? Who's responsible if you get audited? What if, we don't even handle the money? I mean, is it fair to hold us responsible for sales tax? We didn't even collect the money. And so the MTC has really been trying to get ahead of this, the Multi-State Tax Commission, and we really provide some guidance and a model statute to provide some fairness and to help the states to sort this all out, and also not to create additional angst for taxpayers. So the MTC working group, they developed a white paper that has been finalized. You can just Google it. You will be able to find it on the MTC site. And here, I won't go through for sake of time all of the issues. They're listed here that they want to sort through for the marketplace provider and facilitator and who has what requirements. But if you are selling through a marketplace provider, you want to make sure you understand if that marketplace facilitator is alleviating your responsibility or not, who can be held liable. You want to work through these issues. And the other issue is, I want companies to think, okay, I'm not selling on e-commerce, so I don't have to worry about those rules. You need to think about, am I doing anything that is advertising for someone else's sale and being kind of the clearinghouse for payments? You can be a marketplace facilitator even though you're not, an e-commerce provider. So just think, if you're advertising and helping that sale go through, that transaction go through, you could potentially be a marketplace facilitator and get caught in these rules. So we can go to the next slide. It just lists additional items that the MTC is working on. I say that please, if you have anything in that environment where marketplace will come into play, you're going to want to look at this and keep an eye on the states and what they are enacting. We're hoping that they enact an MTC model language, because it actually gives a choice where the marketplace facilitator can say, okay, for this state, the marketplace seller is actually going to collect, because the marketplace seller already has a system in place. Why are you going to make the marketplace facilitator set up a whole system and collect on their behalf if it's already being taken care of? So that model statute allows kind of a choice, and you certify to each other who's doing what. So very, very important to work through that if it impacts you. So we can go to the next slide. Here we overlay both an economic nexus and marketplace facilitator rules together. There are no states with only marketplace facilitator requirements. Most of them have both economic nexus and marketplace facilitator requirements. Again, we only have two that have yet to adopt legislation for either. You can go to the next slide. Defenses remaining. Here's where I want to spend a little bit of time too before turning it over. Okay, Wayfair, the Wayfair Facts. The U.S. Supreme Court heard South Dakota versus Wayfair, a specific fact scenario. Would that hold up if another sales tax case went up to the U.S. Supreme Court? Well, number one, I will say that I doubt the U.S. Supreme Court is going to take that case, because they were regretting the day they stepped foot into this argument. And I think what Wayfair really did was reverse Supreme Court decision, Quill, that established the physical presence requirement, they basically just reversed that decision. So they basically said, we got into this mess with Quill, with Wayfair, we're getting out of it. and they want Congress to take over. So I doubt they're going to take another case. But South Dakota has some simplification to their process. They used the streamlined sales tax project, and where there was simplification there. There was no retroactivity in their statute. They only had one rate you had to collect. You didn't have to file separate returns. And the threshold was for their market. South Dakota market's a much smaller market than in California, Texas, or New York. By the way, all three of those jurisdictions have a $500,000 requirement or threshold. And it makes sense because they have a larger market. But if you're looking at other states that require local taxes, like Colorado, and require all these local taxes, they probably wouldn't pass the U.S. Supreme Court kind of view of this. And so there can still be challenges based on Wayfair in other states, but I will say that it's going to be difficult to overcome. But yes, they should be abiding by all of these things in order for Wayfair to be effective in their state. But you can see from the maps that they're going full steam ahead. You can go to the next slide. And then this one thing also that I wanted to mention, which is really, really interesting. I've never heard it, even in the tax context before, that the U.S. Supreme Court, the justices brought up, and I thought it was very interesting and could have relevance here to some taxpayers, the Pike balancing test. This is still a defense as well. If litigation pretty much is going to ensue. And what this says is that there can't be a clearly excessive burden on a company in interstate commerce if the benefit isn't there. So the Pike case actually it was not a tax case. It dealt with Arizona. They sold melons, and apparently they grew the best tasting melons they thought, in the world. And so Arizona had a specific law that they had to have certain labeling, and that labeling had to occur in Arizona. And so it was more of a regulation, right? And so this producer of these melons actually had a labeling facility just across the border in a different state, but it wasn't very far away. And they labeled and packaged all their melons in the other state. Well, they violated, this Arizona rule that it had to be labeled in Arizona. Well, for them to actually abide by that rule in Arizona, they would have had to build a facility, over $1 million or more facility in Arizona, when they already had a facility in place that was right there 20 minutes away. So that was an excessive burden on them, that they were forcing them to build a whole facility. So that regulation or statute did not hold up. And it was struck down that it could not be enforceable because of that undue burden. So I thought it was interesting that the justices brought this up, because I could tell you in certain situations, I think for some clients, that having to collect and remit in every jurisdiction could be an undue burden if they're only barely meeting the Wayfair thresholds and their overall sales aren't extremely significant. So that's one defense to keep in mind as well. So let's go to the next. So constitutional, we still have to be constitutional. There's both the Commerce Clause and the Due Process Clause. The Due Process Clause just requires a minimum contact. Generally, if you're purposefully pursuing a market within the state, the courts have determined that due process is met. It's going to be interesting, I think, when you get some of these international companies that are outside of the United States that don't have any filing requirements in the U.S. at all, is due process going to come into play under Foreign Commerce Clause as well? Or again, I'm not an attorney, but you have some of these other issues that I believe that we're going to see more litigation in this area. So let's go to the next slide. And then the Commerce Clause. Complete auto transit is still really the case that we look to for the Commerce Clause. You still have to have a substantial nexus. So in South Dakota versus Wayfair, they found that the substantial connection, that $100,000 was a substantial connection. I find that honestly troubling because in other contexts, 100,000 was pretty low to have a substantial connection, but the U.S. Supreme Court says in the sales tax context that 100,000 was enough. Again, I think the transaction test of 200 transactions, many states don't have a transaction test because I don't think that would hold up in the courts. Again, if you only have $200 of revenue in a state because it's $1 a transaction, I don't think that's going to hold up in the courts. I think really the revenue threshold is the one that really needs to be abided by, or the more important of the thresholds. But now the states are really becoming empowered. Wow, 100,000 is enough. And so, you know, we're going to have trouble at the constitutional level because you have to litigate, right, to get there and try to overturn some of the ways that these rules are being applied. So then we come from Wayfair and what's a substantial nexus in Wayfair, and then how does that now creep over into other taxes, into not just sales tax, but into the other tax areas. If you could go to the next slide.
All right, so before we tackle that question, let us get our second polling question up, Chrissy. And that is, can economic nexus apply to income tax as well as sales and use tax? So far, Wayfair has been applied pretty rigorously to sales tax, or enthusiastically, I should say, by the states. So can economic nexus reach out and touch income tax as well? Give us your thoughts on that. Yes, no, or not sure. So we're just, again, checking your attendance here. And on that next move. So these nobody's brought up these defenses, at least for sales tax purposes yet, but there may be some other cases down the road and on the horizon that we'll see. All right, one more moment here on polling question number 2. Make sure you get that marked for your attendance purposes. And okay, Chrissy, I think we're ready to close that and move on to the next challenge.
So what I would say is that, okay, now let's look at income tax. I will say I had been asked a question a lot when Wayfair went through, okay, well, what does this mean to income tax? And, you know, states had kind of eroded away at that. So I was like, I don't know how much, but now I'm seeing actually a lot more happen here. So this is, you know, the next level here and really important to understand. And I'll turn it over to Monica.
Thanks, Kathy. Yeah, so we definitely have a lot of questions in our current environment in reaction to Wayfair and what does this mean for income tax. So I'm going to try to talk through some of the key guidance and interpretations impacting Nexus for income tax and take a look at a few states that have already acted in this area. So as Kathy said, in assessing Nexus for income tax purposes, you still have your constitutional protections in play. The due process clause, the commerce clause, it's the same standards and law that we just went over in the previous slides. So in assessing income tax, we have to look at, you know, what's substantial nexus under the commerce clause. What is that 100,000 that they determined, that 100,000 amount, does that rise to substantial activity? Does it satisfy that first prong of the complete auto test? Also, how does the Pike balancing test come in? Would that provide any relief where the statute is just putting too much burden on commerce in relation to the benefit that's provided? Also, taxpayers are just really going to need to look back to the state laws defining what is doing business in the state. So that's, you know, your imposition statute of if you're doing business, then you're subject to our tax. And then also with that is now we have this, if you're deriving income from sources within the state. And since this concept of economic nexus is gaining momentum and really pushing the boundaries wider, so looking at, just all the different ways that the state can get you, one of the biggest challenges is understanding how the sourcing rules interact with the nexus determination. So and by sourcing, I mean, how do you determine how many sales you have in the state? Are you determining that sourcing, the amount of sales in the state first, and then you determine your nexus, or do you determine whether you have nexus first and then how you source it? So arguably you need to look at both now, and depending on what your business is and what your state activities are, nexus has always been a very fact and circumstance analysis. There's some cases where it's clear cut, but in a lot of cases there's a lot of gray, and it really is dependent on what are the specific facts and circumstance of what you're doing in that state. Now we're looking at not just your physical presence and your activities in the state, but also the revenue that's coming from that state. With economic nexus, sourcing is it's just more important as another consideration in making that nexus determination. So we're extending that interpretation to look at your customers and the revenue that's derived from the state. Economic nexus is, not dependent on the physical presence, and that goes back to when we look at Quill, which was the case essentially that Wayfair was looking to. That was a 1992 Supreme Court case, and the court determined that some physical presence was required in the sales tax context. That was a sales tax case. It didn't apply necessarily to other taxes, although other states did use that, sometimes to push in and say, yes, so that we need that physical presence for income tax as well, or other taxes. But under the case itself, that was a sales tax case. So back to due process and minimum context that can be present when the business purposefully pursues the market and targets its activities to the state to get its business. So that's really the requirement that needed to be satisfied. So even before Wayfair, some states were applying an economic nexus concept to income tax, and now the majority of states would agree that nexus can be triggered for that income tax or gross receipts tax by receiving a certain amount of revenue from the state. Multi-state tax commission, they had enacted factor presence standard of nexus back in 2002. So this model law provided that substantial nexus is established if any of the following three thresholds is exceeded during the tax period. So the first one, 50,000 of property in the state, or 25% of total property, or you have 50,000 of payroll, or 25% of your total payroll, or, and this is the, kind of the controversial one, 500,000 of sales, or 25% of total sales. These bright line standards for factor presence have been in place since 2002, well before Wayfair, 18 years. And a handful of states adopted these standards or something similar in the past 10 years or so. So this is not new in the income tax context to have this principle of economic nexus. It's just that the sales threshold was a lot higher than what Wayfair validated with the 100,000 in South Dakota. So, the question then is now, what are the states going to do with this? Are they going to, like Kathy was just mentioning, is 100,000 enough? Maybe it is in South Dakota, or a less populated state, but what about the higher populated states? Is that enough? Will states reassess this and look at what should that dollar amount be? So there's a lot of states that are really studying the impact of this. So we're going to turn now to another protection, federal law protection, or also known as Public Law 86272. And we have a polling question here.
That's it. So we'll start this section off with the polling question. Chrissy, if you'll go ahead and pull up polling question number 3 for us. Let's get number 3 pulled up for the group. Let me see. All right, so we got our poll going, and on this one, Public Law 86-272 protects all businesses from the impact of economic nexus. 86-272, this law has been around for a long time, and we've used it frequently. It's been a hallmark and important law in the same way that Quill has been a critical decision, and Wayfair is now one of those critical Supreme Court decisions. This Public Law 86-272 has been a very important part of our state and local tax services and compliance. So while folks are still weighing in just a moment there on this, we'll get ready to move forward. But before we do, while folks are answering this question, Monica and Kathy, you guys both mentioned the Multi-State Tax Commission, MTC. Can you just give us a brief overview of what that commission is and its role?
Sure. It's basically an intergovernmental state tax agency, and their mission is really just to promote uniformity and consistent tax policy and administration among the states. And it's also meant to, help taxpayers achieve compliance and understand the existing tax laws and really promote good tax policy.
All right, great, thank you. Okay, Chrissy, I think we're ready to close that poll on question number 3. And let's go on. And Monica, tell us about Public Law 86-272.
Yeah, so Sarah, you're right. This has been around for a while, and it's become more, I think, important even today now. And just there's some definitely some states are taking a closer look at this and how today's economy and activities in today's economy play into this law. So the law is basically, in the next slide, saying states may not impose net income tax if the only business activity in the state is solicitation activity for the sale of tangible personal property. So there's some key elements there. This isn't going to apply to everyone because it doesn't apply to services. And on the next slide, you can see what limits on this scope of protection. So it does apply to net income taxes. It does not apply to other types of taxes like gross receipts taxes or franchise or net worth taxes or sales taxes. It applies only to sales of tangible personal property, not to the sale of services or intangibles. It applies in interstate commerce, not in foreign commerce. And it applies to businesses that are not domiciled in the state. It does not apply to, if you're an entity that's organized in the state, you would still be subject to the income tax. So that's a pretty specific protection, but when it does apply, it will trump these economic nexus laws that the states may have. So that's where it's really coming into, greater importance is, there's a lot of confusion, I think, in this area because of all the talk of, X dollars of revenue from the state, then suddenly you're taxable. But you still have this protection for income tax as long as you're meeting these other the scope, if you're within the scope of only the sale of tangible property and only for income tax. So the key is to analyze when this applies to you. And on the next slide, it is a narrow protection that it requires a little bit of analysis and monitoring of the activities, because typically these are the activities conducted by your sales team. And you would just want to, make sure it's not serving an independent business function beyond that solicitation of orders. And the Wrigley case from 1992, the Supreme Court looked at this and held that solicitation includes not only actual requests for purchases, but also other activities that are entirely ancillary to the request. So in essence, that just means they can't serve an independent business function apart from the connection to the solicitation of orders. So this is very facts and circumstances determination as well. What are you doing in the state? And a recent case, actually, December 2019, the Maryland Court of Special Appeals affirmed that a manufacturer's regular gathering of competitive information in Maryland exceeded the protections of Public Law 86272 and going beyond in-state solicitation of orders. And it wasn't just a de minimis activity. So the company did owe Maryland corporate tax for the years at issue. So under the facts of this case, the company employees were in Maryland and they were sales employees mostly, but they were just gathering competitive information and intelligence about the competition, basically. And this was deemed to be not ancillary to the solicitation of sales, and therefore, they were taxable. So that's a good illustration, I think, of, just kind of how far does 86272 extend, and what are they considering ancillary to solicitation activity. And then this is really important and just shows, what's going on to change laws here, in response really I guess it's partially Wayfair driving this, but partially just, it's showing how the states are getting more aggressive and more, conversation around our digital economy and how can we make these laws more clear for taxpayers and for the state administrators to be able to tax. But the MTC, again, Multi-State Tax Commission Policy Group, they are currently updating their guidance on how Public Law 86272 should apply to various business activities in today's environment. So they've revised this statement multiple times before, most recently in 2001, looking to what business activities are being conducted in the state. And they've got a work group that was formed at the end of 2018 and had various meetings throughout the year to basically draft an entire new section related to their statement on Public Law 86272 to focus on activities conducted via the internet. So the next slide.
Monica, I would just add, I'll just jump in here real quick. Yeah, I'll just add that, this is the MTC's kind of guidance, but it's really up to every specific state on how they apply it or they choose to apply it. But it's over 20 states. Whoever is a member of the MTC group, unfortunately, doesn't include the big states like New York, Texas, and California, but a lot of the other states get on the same page with how they think it should be imposed. Yeah,
and I agree, and it definitely that's a good point, and it provides guidance to taxpayers. But again, it goes back to what specific state are you acting in. This draft section is really looking to customer interactions within the state as equivalent to being business activities in the state. So they're setting up that as a general rule, when a business interacts with the customer through its website or even an app, then the business is engaging in activity in the state. So the key is that interaction with the customer. So it has to be more than just viewing the website or viewing photos or viewing static content like FAQs on the website or photos. That would not necessarily rise to a customer interaction. But other things have been identified as unprotected activities. And the working group is really trying to provide specific examples that will be incorporated into its statement to give taxpayers more guidance and have just more clarity, which is a good thing, I think. But on the other hand, they're yes?
Oh, I'm sorry. I thought you were pausing. I just wanted to say one thing there, and sorry for the interruption, but if you think about before computers, people had phones, right? They're calling the states, calling to solicit credit cards, calling to see if they needed anything else. Now, this is monumental because now the states are saying, if you do it over the internet and it's showing up as a chat box on a computer in that state, that's actually you conducting activity in the state. Where before, how is that different than a telephone? And that's what's really problematic. I've sat in on these calls, and even though you could have done this by telephone and it was protected, now they're saying because it's done by computer, it's not protected. So this is problematic. But I'll stop interrupting. Thank you, Monica.
Yeah, absolutely. On the list of this slide, the list of unprotected activities is just what Kathy's referencing, the post-sale assistance to customers. Suddenly, you can't do that via your e-chat, but yet if you handled that through a 1-800 number, then that's not Nexus, right? So that doesn't make a lot of sense to me either. But that's where they're kind of drawing the line on specific examples of customer interaction, and there's definitely some, I think, controversy on some of these points here. But remotely fixing the product via the internet, streaming videos and music to electronic devices to customers, those are all going to be viewed as outside 86272 protection. We have another slide even talking about the use of cookies and how certain use of cookies is okay. If it's just to exclusively facilitate the sale of the TPP, that's okay. But if you're using the cookies for other business purposes, like your production schedule or adjusting your inventory or developing new products, that is not okay. That's beyond the scope. If you're selling that information that you've gathered through the use of cookies, that's also not okay. If you're, and then the sale of business and treatment of goodwill, also not protected under Public Law 6272 because that is not goodwill. And one other point I didn't point out on the prior slide, Sarah, if you go back, is the solicitation and receipt of online applications for credit cards for the company's website. If you're doing that through the website, if that pops up during the customer's use of the website or is available on there, then that is also deemed unprotected. Okay. Yes, that's the slide. So if software is classified as TPP under state rules, a license would not be protected as that's viewed as similar to leasing of property. And then we have more complicated areas such as cloud computing. This is just not going to be addressed because there just isn't as much law in this area, and it's been noted as something that is still problematic. So now we're going to turn to what's happened now. What have the states done? What are the law changes? How has Wayfair impacted income tax? And we'll start off looking at Philadelphia has new economic nexus. So the city of Philadelphia, their business income and receipts tax, after the Wayfair decision, Philly amended its business income and receipts tax to adopt this bright line economic nexus standard for tax years beginning January 1st, 2019 and after. So under this new standard, a business with no physical presence in Philadelphia will be considered to have nexus in Philly and subject to the tax if it's generated at least $100,000. There's the same Wayfair amount in Philadelphia gross receipts during any 12-month period ending in the current year, and if you have that sufficient connection with Philadelphia under the Constitution. So they put that in there to meet that constitutional requirement. This tax, they're respecting Public Law 6272 for the income piece of the tax, but not the gross receipts portion. So that's been clarified, although that would still apply, 86272 would still apply even if they were silent as to that fact. Pennsylvania, the state, the Revenue Department has issued guidance that applies the Wayfair reasoning also to its corporate net income tax. So here it's 500,000 gross receipts threshold for tax periods on or after January 1, 2020. If you have over the 500,000, this will create Nexus for corporate income tax. And they've released guidance in September on their tax bulletin 2019-04, saying that, you know, if you qualify for the H-6272 protection, you should still file the corporate tax report, the RCT 101, and complete the schedules to claim that exemption from tax. So I think we'll see more of that, especially as, you know, more states have, you know, multiple tax bases or a franchise tax in addition to an income tax. Next, we have Hawaii. They were the first state to enact a Wayfair type threshold for income tax purposes, and this is effective for tax years beginning after December 31st, 2019. They use the 200 or more business transactions or gross income attributable to sources within Hawaii equal to or exceeding 100,000, so the same Wayfair threshold amounts. They're also enacting market-based sourcing, looking to the customer at the same time that this law goes into effect. You know, again, back to it's important to how you source your sales when you're determining whether you're meeting these thresholds or not. And then, of course, you want to consider Public Law 6272 protection if that can apply to your business. And then finally, we have Texas. The comptroller in Texas also has imposed, and recently this passed, I think just at the end of December, $500,000 economic nexus threshold for franchise margin tax purposes. Applies to Texas franchise tax reports due on or after January 1st, 2020. Measured by Texas apportionment sourcing rules. So again, it's very important that you're applying the sourcing rules correctly in determining whether you've met the threshold or not. You also may have automatic nexus if Texas use tax permit has been obtained already. And for Texas, unfortunately, there is no Public Law 6272 protection since the margin tax is not an income tax. So again, 6272 does not apply to taxes other than income taxes. And with that, I think that's the end of our content for today. And we've got to a polling question.
Great. So we are now, Chrissy, if you'll bring up the fourth polling question. Thank you. So this is a question we'd like to hear back from you. Are you seeing currently some state law changes for economic nexus, either for sales and use or for income tax or gross receipts, as Monica just mentioned, that are impacting you or your business? So we'd like to know, are you already seeing some law changes that are making an impact, maybe some additional reporting requirements, some more confusion in compliance and things? Are you already feeling this pinch as the states adopt changes in connection with Nexus? And then we've got just a couple of minutes left here, and we'll see if you have any questions and you'd like to put them in the question pod, or Kathy, if you had a chance to look at those questions, are there any that you'd like to answer here, or some final comments as we wrap up? So one more minute, one more brief moment or two here on this polling question number 4. Make sure you get an answer in to earn your CPE credit. And then let's see, one more moment, and we will wrap up with any questions or comments, final comments we have from our presenters. Kathy, you want to go first? Any final comments?
Yeah, the final comment I would make is you really need to look at your sales by state based on where your customer is located for both, for any type of tax. And then really talk to your the income tax provider, sales tax provider, contact us or whoever, but take a look and see, is this amount of revenue from the state a problem? Do I have a filing requirement? Do I have any protections? But you really, historically, we'd look at where property and payroll is, but now you really have to look at where is our revenue coming from. And I think that's it. And Monica, did you have anything else?
Yeah, I definitely agree with the revenue sourcing being so important. And then the other thing I would say is that Public Law 86272, if you are claiming that position, I think it's really important to revisit that annually and make sure that the protection applies, because I think it's just getting narrower, and it's just something always to look at. And I have seen situations for clients where they haven't necessarily kept up with what's going on. It's a year-to-year determination of the activities in the state and whether that protection still applies.
Okay, I think with that we can wrap it up.
All right. Well,
thank you, everyone.
Thank you all. We appreciate your joining us today. And Chrissy, any final words for the audience as they're logging off?
No, everybody, just thanks for joining us today. And if you wanted to earn CPE, as long as you answered the polling questions, you'll earn that CPE, and you'll get an email with your certificate of completion in about 3 weeks. So be on the lookout for that email in about 3 weeks. But that's all. Thanks, everyone, for joining.
Thank you all for joining us this afternoon.